All right, so I'm going to get started. Again, my name is Tasha Poinsett with the Healing Advocacy Fund, and really excited to have you all here for a webinar focused on dual licensure in the state regulated psilocybin therapy programs in Oregon, Colorado, and New Mexico. We have a really fabulous group of panelists here, including representatives from 3 separate wonderful law firms in the space, as well as Jason from Portland Psychotherapy. And so I'm just going to start out by giving a high-level overview of our work at the Healing Advocacy Fund, as well as the basics of the state-regulated psilocybin therapy programs. Hopefully this is familiar for a lot of folks on the call, but we just want to make sure that everybody's kind of on the same page going in. So our mission at the Healing Advocacy Fund is to expand and protect safe, affordable, state-regulated access to psychedelic healing for all who need it. We're a 501c3 nonprofit. And really how we do that is working across the 3 states that have created legal access models for psilocybin therapy to support the implementation of these programs in a way that centers safety, responsible practice, and then trying to work towards greater affordability and access as these programs get up and running. So we currently have a team in Colorado and Oregon. We've been working closely together over the past couple of years, and then most recently brought on our colleague in New Mexico, Denali Wilson, who's also here on the call with us today. And so in terms of what we're talking about when we talk about these state-regulated psilocybin therapy programs, there's a few common components across all 3 of the state models. It does vary a little bit, but high level, it's a regulated access model where folks who are seeking access have to be 21 plus. They're going to reach out, they're going to do an assessment and safety screening to identify any contraindications with psilocybin. They're going to complete at least 1 preparation session with a trained and licensed facilitator, talking about their goals for the session, developing a safety plan, and otherwise preparing for the psilocybin experience. And then these are supervised models, and so they're going to be administered the psilocybin at a licensed location or possibly an approved location. That varies a little bit by state, and we can talk about that more later on in the webinar. But the session is going to be facilitated and overseen throughout by somebody who has received training from a state-approved training program and is there to support that person through their psilocybin experience. And then finally, the last step is integration, where they're going to work with that facilitator to discuss what came up and process the experience, hopefully be able to integrate changes into their lives going forward. So in terms of where we are in the state programs, Oregon, as many of you probably know, has had a live program for since June of 2023. So 2-year rulemaking process to get that set up. Been seeing clients for about 2.5 years now, and 14,000 people at least have now gone through Oregon's program. Really starting to hear some exciting testimonies and results from those experiences. And then we're also learning more as Oregon has implemented kind of high-level reporting for the program, which is exciting. In Colorado, we passed our initiative in November of 2022. The legislature in Colorado then turned around and rewrote the entire initiative within a few months. And so that was a fun process to engage and make sure that they kept the core components of Proposition 122 intact, which largely they did. And then rulemaking took place. Colorado began licensing facilitators and healing centers in January of this year, and the first clients went through the program in June. I'd say that Colorado's healing centers, many of them are just now kind of getting farther along in their process of actually working with clients, which is exciting. And then I'll hand it to Denali to share a little bit about New Mexico's timeline.
Hey everyone, glad to be here with you and excited to be representing New Mexico, the latest state to come online with a state-regulated access program. We're really grateful. I see Senator Jeff Steinborn in the audience. It was his leadership that led to the passage of SB 219, making New Mexico the first state to create through legislative initiative rather than ballot initiative, a state-regulated access program. New Mexico is also the first medically integrated program, meaning that you have to be a licensed healthcare provider and patients seeking care have to have a qualifying medical condition, which has a lot of relevance for the questions here today around dual licensure that we'll be sure to get into in the future. We're early in the process. We're still waiting for an advisory board here in New Mexico, but the department has the next 2 years to develop rules and regulations. We're expecting permitting to start for both cultivators and providers in March of 2027, and then the program will launch at the beginning of 2028. You're muted, Heidi, or Tasha.
Dang it. Thank you for that. So before we get into the rest of the discussion, just want to give you high level a sense of what are some of the similarities and differences across the 3 state programs. So in all 3, we're referencing natural psilocybin, so cultivated mushrooms when we talk about psilocybin. Colorado also has the option to add a few other plant-based psychedelics to its program, but so far we're just talking about regulated access to psilocybin. In both Colorado and in Oregon, folks can become facilitators if they have a high school degree and complete the requisite state mandated training, and of course apply for licensure. Colorado does have 2 options for license types. So there's a facilitator license or a clinical facilitator license. Somebody who's a clinical facilitator is dually licensed with a license that allows them to practice either medicine or therapy. So really you're thinking doctors, therapists in that category. And then folks who are facilitators may also be dually licensed with other, acupuncturists, RNs, other areas that are health and wellness related, but not specifically allowing them to diagnose and treat. And then in terms of eligibility for who can access, in both Colorado and Oregon, it's anyone who's 21 plus. Oregon has pretty clear exclusion criteria, 3 sort of areas where people would not be able to move forward with access if they fall into those categories. Colorado doesn't have exclusion criteria, but we do have a required screening process that focuses on risk assessment and then informed consent. So if somebody is flagged for having higher risk in a certain area, they would need to either have clearance, a referral, or complete a consultation and risk review with somebody who has a license to diagnose and treat that specific risk factor that was identified. And then finally, there's some differences in terms of location. So in Oregon, all services are taking place at licensed service centers. In Colorado, we do also have licensed healing centers. That is where the majority of psilocybin therapy sessions are going to take place. But we do have allowances for at-home session for certain eligible clients. That would be people who are living with a disability, are homebound, or are receiving palliative care or hospice. They could complete sessions at their home subject to additional safety requirements. And then we also have 2 different license types for healing centers. We have micro healing centers, which tend to be smaller practices. And then we have standard healing centers, a little bit larger. They can store more psilocybin on site. And we allow for co-location in a way that Oregon doesn't quite. And so you can have, for instance, a therapist's office that becomes licensed as a healing center. And there's going to be, therapy practice there as well as psilocybin therapy in the same space. And then I will again hand it to Denali to just share a little bit about how New Mexico is unique.
Thanks, Tasha. When it comes to the substance that is regulated in the state regulated access program like Oregon, we are regulating natural psilocybin. That's what the program provides access to in a therapeutic setting. Unique, right? As I mentioned, New Mexico is the first medically integrated model. So that means that to be a provider, you have to already be a licensed healthcare provider in the state, and of course, receive training and approval from the Department of Health. One of the big questions we have, and will likely be among the first answered in the rulemaking process by the Department of Health, is who qualifies. What licenses are we talking about within the existing healthcare continuum here in the state? And then relatedly, right, as a medically integrated model, individuals seeking care must qualify. So there are 4 enumerated conditions in the legislation and a catch-all for additional conditions that are approved by the Department of Health through a petition and review process that's very similar to our medical cannabis program. So the qualifying conditions are substance use disorder, major treatment-resistant depression, PTSD, and end-of-life care. And then another question will be what the legislation lays out permitted locations, which is not defined and will be defined by the regulatory process. And we hope for something expansive that iterates on the lessons learned in both Oregon and Colorado.
All right. So in terms of where we are in the programs in Colorado and Oregon, Oregon has, so Oregon has 25 licensed service centers across the state. Colorado already has 22 licensed, although 14 of those are micro, so they may be, significantly smaller practices than some of those healing centers or service centers in Oregon. And then we also have more licensed facilitators in Colorado now than Oregon, with the caveat that the vast majority of those folks are facilitators in training, meaning that they've obtained a training license, which does allow them to begin facilitating while they complete the required 40 hours of consultation with somebody that's more experienced in facilitating with psilocybin. And then, as I mentioned, 14,000 people have gone through Oregon's program. In Colorado, we don't quite have those numbers yet in terms of how many have gone through. We are hoping that we'll have more information about that by the end of the year. And with that, I'm going to stop the screen share. And we're going to jump into sort of the featured event for today, which is the moderated discussion led by Jason Luoma of Portland's Psychotherapy. And I just want to encourage folks as we're going through this discussion, Jason has a number of questions that he's going to direct to the 3 law firms. But if you have questions that are coming up, please do go ahead and use the Q&A function, and then we'll have time at the end of the call to go through those questions. And I will also say this is being recorded, and we will share the recording of the webinar out with all registrants after the call. So with that, I'm going to hand it over to Jason. Thank you so much, Jason, for joining us today.
Thanks. Yeah, it's great to be here. My name is Jason Luoma. I'm a clinical psychologist, and I run Portland Psychotherapy, where we are a social enterprise that provides clinical services, but also funds scientific research. And the main thing we're funding these days are clinical trials on psychedelics. So we finished one on MDMA and are doing another one with psilocybin shortly. And that's through our Portland Institute for Psychedelic Science, where we do the research and we also provide clinical services. We're trying to get as close as you can to what is done in the clinical trials with psychedelic assisted therapy by working with the Oregon program. And so we're really interested in this topic of dual licensure and integrating healthcare, licensed healthcare with what's happening in these state programs and all of the complexities of that. And it's my pleasure to have this fantastic and knowledgeable group of attorneys here who have been studying these topics and have so much to share. So we're going to start off by just giving each person a few minutes to introduce themselves, and then we'll jump into the questions. And I think just looking at the order I have listed here, it looks like Casey Homan from Emerge is up first.
Hi, everyone. Thanks, Jason. My name is Casey. I am a business attorney at Emerge Law Group, based in Portland, licensed in Oregon, Colorado, and New Jersey. We're a boutique full-service law firm with a lot of clients in the cannabis, psychedelics, and healthcare spaces. And our attorneys, including myself, were on the drafting team that legalized psilocybin services in Oregon back in 2020. So we've been deeply involved in Oregon State Regulated Program from the beginning, and I'm looking forward to the discussion today.
I think Joshua, you're up next.
Awesome. Thanks, Jason. And thanks, Healing Advocacy Fund, for putting this together. My name is Joshua Kaplan. I'm one of the founding partners at Vicente. We're a law firm that does work all over the country, around cannabis and psychedelics, on the policy side, on the business side, compliance, litigation, et cetera. But specifically, I was had the privilege of being one of the main drafters of Colorado's Natural Medicine Health Act. And sort of like when we were putting together that law, there's this dream about integrating facilitation into our mental health system, and here we are today with like that dream coming true. So it's like really an honor to be here. And, and in addition to, sort of my hat that I wear at Vicente, I'm also a policy advisor at the Healing Advocacy Fund, which is really leading the charge to make sure that access to psychedelics at the state level can be done as affordably and as efficiently and effectively as possible and safely. So thank you for having me.
And Victoria, you're up.
Thanks so much, Jason. Hi, everyone. My name is Victoria Svetanovich. I act as of counsel to Ruddick Law Group. We're a plant medicine-based and focused law firm. I run the psychedelic medicine side of the house, as well as the cybersecurity data privacy practice, and practice in corporate and healthcare law, along with my cannabis and psychedelic medicine practice. I'll echo Josh's thank you to the Healing Advocacy Fund for putting this together. And I'd also like to add a thank you to everyone who decided to participate in this webinar today. These programs only work when people understand and participate in them. So thank you for taking the time to gain a deeper understanding of how this might work with your practice.
All right, great. So let's jump into our first question. This is a really broad one, and I think we're going to start off with Joshua commenting on it, but everybody else can also comment as well on any of these. So the first one is, overall, what do you see as the main risks for healthcare providers, licensed healthcare providers who want to be involved with these state legal psilocybin services as facilitators?
Yeah, thanks for the question. And it is, we'll dive into a lot of these issues more specifically, but really there's sort of good news and bad news here. On the bad news front, there's a fair amount of risk. It's not, it's an area that is very new, and there's really sort of like three buckets to think about. One, with these state access models, the whole program's still illegal federally, so that there's this federal illegality that creates a bucket of risk. And then you have sort of this, it's really new. What we're doing here today is, you saw the previous slides, like we're 4 months into Colorado's program. We're just adding dual licensure in Oregon. It's really new and things are constantly changing. And so that's like something to think about as well. And then you're in a regulated profession. And so you have different regulatory bodies that sort of also oversee your license, whether it's the facilitator license or your other professional license in Colorado. And so those three buckets create a fair amount of issues to navigate. And then inside of those, you have questions around, does your insurance cover this? How is your licensing board treating this? In Colorado, there's certain licenses can be, quote, like a dual, like a clinical facilitator, and other licenses can't. And so like first you have to check, like, is the license you have, does it even qualify to become a clinical facilitator? And then if so, you're bound by both ethics rules. And so like, how does the practice of psychology work with the practice of facilitation? So there's like some interesting things to unpack there. And then, there's other issues we'll get into, with like third-party payer contracts, or in referrals or insurance or screening. There's all these different issues to like unpack, and I'm excited to dive into those. So that's sort of like the risk. But the good news about this is that like there are duly licensed facilitators in Colorado providing services today. So like these risks like are things we can navigate. There are some unknowns, but it is something where it's like it is working. Our system's working, and it's still very new though. So I'll stop there and let other people chime in.
Yeah, anyone else want to point out the risks that?
Yeah, I'm happy to maybe add to it. I think Josh is right that we're going to kind of get into the nuances of some of these risk elements later, like insurance and referrals and dual relationships and some of those really, big topics. To kind of set the stage for the conversation, I think it's kind of important to point out here that the risks differ depending on whether a provider intends to practice simultaneously or not. And then also for Oregon, I kind of want to set the stage, which I think is very similar in Colorado as well, about the dual licensure. So the new law in Oregon goes into effect January 1st. Like Josh said, it's very new. It's not been tested out in Oregon. Everything's sort of theoretical at this point. But the law authorizes certain professional licenses to simultaneously practice healthcare, behavioral healthcare while facilitating during a preparation and integration session. That's not every licensee in Oregon. You need to check and ensure that the licenses that are listed is a license that you hold if you're intending to simultaneously practice. And then the law also just protects healthcare providers, which is a much broader term, from risk of civil penalty or disciplinary action by a professional licensing board for either providing psilocybin services, on the side, just in your capacity as a facilitator, or discussing psilocybin as a treatment option. And I would just add to what Josh said about insurance gaps and some of these big risk buckets, that providers also really need to think through their business structure, and carefully consider whether it's even desirable for them to simultaneously practice, or if there's a way that we can potentially find to bifurcate services in a manner that meets the provider's ethical obligations and is also legally sound from a business structure standpoint. And there's certainly risks involved in that approach as well, that providers would have to get comfortable with. But we all know that these services are incredibly unaffordable. And if there is an opportunity to potentially bill a client's health insurance by bookending sessions, I think that we have to seriously consider, mechanisms to do that, and not, discount the possibility of creating a business structure that does that, which requires a lot of really well-written documentation, and super clear understanding from your clients. But I'll stop there and we can get into some of the nuances a little later.
I'll jump in with a few of what I like to tell my clients are kind of forgotten risks. And these are especially applicable in New Mexico because we are talking about a medically integrated model, but they do apply to other people who are dealing with dual licensure. The first is mismatched compliance responsibilities. This is particularly true in cybersecurity, but it happens in other areas as well. Because the United States does not have a comprehensive cybersecurity law like Europe or parts of Asia, every state has its own cybersecurity compliance rules that fill in certain subject matter in certain areas. And then we obviously have things like HIPAA High Tech that cover healthcare providers who are working with insurance at some part of their practice. Oftentimes, and this happens in every kind of state program, not just state programs that deal with psychedelics, we see a mismatch between what a provider is already required to do with their data and what the program is asking them to do with their data. So, like Casey said, bifurcating your services or practice and looking at your corporate structure to make sure that you can actually meet those compliance obligations that you already have before joining a new program is incredibly important. I also like to talk about predatory financing as a risk when it comes to these new state programs. Standing up a healing center, starting a new practice might be very expensive for you. And you might be looking to investors or new partners to make this something that's viable. What we've seen in medical cannabis, as well as with ketamine clinics, is that few investors willing to take the risks that Josh and Casey have outlined often leads to very, very favorable financing terms for investors that may be predatory. They may include things like hidden or disguised interest, fees, being on both sides of the money. These things can be very complicated. So as you're thinking about whether or not this is viable to you from a practice standpoint of offering medical services, I encourage you to also be thinking about whether this is viable for you financially and to truly understand whether your corporate structure and the financing that's being offered to you are mutually agreeable in such a way that this is going to benefit you in the long term. Lastly, I always tell people to start getting comfortable with the idea of board complaints. The threshold for filing a board complaint in most states is very, very low. And there are going to be people as we go through this new and exciting developmental process who don't understand or who disagree with the way that practitioners decide to practice within these programs. Being prepared to face that kind of risk and to stand up for the work that you believe in will make you a better practitioner and will make you someone that your patients can truly rely on.
Wow. All right. So tons of things already out there. I think we could spend a week in this webinar, but we'll keep going. Next question is about documentation practices. What kind of documentation practices might you recommend for dually licensed providers? This is, I think, Casey's up first.
Sure. So if someone is practicing simultaneously, then they need to consider the fact that they need record keeping requirements that meet the obligations of their professional license and the obligations of the OHA for their facilitator license. So that's important. In Oregon, there's a few different business models that our clients will operate under. So, we have templates for each different business model, client services agreements, releases and waivers of liability. And the specific provisions of those agreements depend on the business model that the provider is going to utilize. So is the provider simultaneously practicing? Is the provider just providing psilocybin services solely as a facilitator on the side? The answer to that question, will dictate the various disclaimers and language included in service agreements. Release and waivers of liability are extremely important. They're a creature of law. They need to kind of look and feel a certain way for them to be legal and binding in a particular state. And even if a provider is not providing psilocybin services and is really just discussing psilocybin as a treatment option with clients, ideally, there's going to be a document of some sort between the provider and the client concerning the scope of that discussion. As I mentioned, in Oregon, providers can discuss psilocybin services as a treatment option, and that's very limiting language. And so we want to make it clear to clients in this circumstance what the provider is not doing, right? Which is recommending or encouraging use. I'm just discussing as a potential treatment option. You're coming to your own conclusion. There's specific language that is important in these documents. And so smart, tailored contracts on the front end can help protect from liability on the back end, and can just illustrate to a court or a jury that you are professional, methodical. You've clearly articulated the boundaries of your professional relationship with your clients, and that all looks good in the eyes of the court, if anything goes wrong later.
Yeah, if I can add a couple pieces to that, and in case I think that's great. There's in Colorado, there's a set of forms that everyone needs to utilize. It's sort of like the base set of forms. But there's nothing that prohibits a facilitator, a clinical facilitator from adding additional forms. And then there's different things you want to think about, in terms of informed consent or waivers of liability, and also like in some cases, like are those waivers even enforceable, because they're generally not enforceable in the healthcare field generally. So it's just things to think about, like, hey, how do you take like what's required as the base and then add onto it? There's also, as Victoria mentioned, like being prepared for DORA complaints or board complaints is a real thing. And, we've dealt with a number of our clients have received them in Colorado. And it's, because in Colorado, it's complaint based. So anyone can file a complaint, and then you get a letter from DORA that says like, what's this about? So like, having the documentation is like so necessary. And so like, if you're a physician that's providing, let's say you're providing screening to patients, or patients or participants are coming to you because they're high risk and they want clearance, like having very clear documentation around what you're saying, what you're relying on, is very helpful, both like, if there is an issue in the future, and also, whether it's from DORA or whether it's a liability suit, but just really like making sure you're grounded in just like what are the best practices in this emerging space, even though there's like not a lot of standards of care that are developed. We're actually like sort of like developing the standards of care for each of these professions day by day at this point, but like sort of like documenting like what is out there is also really helpful if you're, if you're going to sort of work with someone on like a risk review in Colorado, or you're going to try and like clear someone, which there's issues with sort of like quote clearing someone regardless. But so a lot of it too on the documentation is trying to figure out like what exactly you're saying. Like if you're, like are you sort of like recommending, or are you sort of like not, are you saying that there's nothing like that disqualifies them? So there's a lot of just different nuances, and it's worth going above and beyond what is mandated with the state, but also you have to use like the state forms, and there's a lot of great compliance software pieces out there that can like help you with that as well.
Those are both phenomenal answers. I'll just add on, in addition to paying attention to the content of the documentation that you're preparing while participating in these programs, pay attention to your data flow and your data life cycle and how these things are stored. As I mentioned in my previous answer, you might have a lot of cross-cutting data privacy responsibilities based on your license, the state in which you live, and also the country in which you live. The way that you store this data that you're taking in and the way that you protect it is essential to whether or not other states and other citizens will trust that these psilocybin programs that we're developing are safe places to share their data with. There was a survey done last year that I took the liberty of reading this morning that showed that a data breach is the #1 reason why a healthcare patient would not go back to a specific practice. It feels really violating to be opened up to that kind of exposure and to lose these really, really tender moments in your life to the anonymity and exposure of the internet. We all know that psychedelic assisted therapy touches on very, very personal areas of people's lives. And so if we as practitioners in the space can understand how it is that we're protecting the data that we're entrusted with, we're better prepared to help people trust these programs long term.
Okay, moving on to the next question. This one is about a healthcare provider who's not a facilitator. So if you have someone who's not a facilitator and they want to refer into one of the state legal programs, what are the kinds of things they should keep in mind? What are the main risks that they might be facing by making referrals? I think this is Victoria first.
Thanks so much. I'll start with what you should keep in mind because I think it informs what the major risks are. First, payment issues. Does the patient understand what the potential private pay costs of receiving a referral into one of these programs is? Next, consent. Does the patient understand what information is being shared with the program facilitator and or the state, depending on the program, when they are receiving one of these referrals? Third, data privacy. Does how you're giving this referral comport with not only your responsibilities under the state program, but any federal data privacy laws that you're subject to, like HIPAA High Tech, and any state cybersecurity laws? Here I'll insert, do you need a business associate agreement with the particular facilitators that you're working with based on your state and federal responsibilities? You might, depending on your situation. I'll also hit on an issue that both Josh and Casey have talked about, and that is the idea of medical free speech versus aiding and abetting. In a statement that I'm sure is not going to be popular on this call, I am a former narcotics and RICO prosecutor. And I think it would be negligent of me not to mention that while medical free speech is absolutely a right, conduct that actively facilitates the acquisition, sale, or attempted acquisition or sale of a Schedule I substance might be considered aiding and abetting. Accordingly, it's a best practice to consider, or an early recommendation as these programs develop, to consider using a patient consent or other documentation that includes language that might be specified by your state or might not yet be specified by your state that makes clear that a referral is simply that. It's an opportunity for a patient to explore another treatment option. It's not a prescription or some kind of command that can be traded in exchange for the receipt of scheduled drugs. With those things in mind, I'll address 3 risks that come up for me. The first is clawbacks. Providers should really think through how making and charting the process of giving a referral in the context of a particular patient's care could result in clawbacks. And they should have a plan to train staff in order to best chart, best explain, best refer in ways that are both accurate to the patient's care and also not going to disturb the insurance payments that have already been received. Next, and I'll hit on this again and again, is cybersecurity compliance. Depending on the state, some psychedelic medicine providers might not be held to the same standard for data privacy as the licensed professional that's making this referral into the state program. Business associate agreements or other arrangements might need to be made depending on context before referrals start being made. Lastly, and most importantly, providers need to be prepared to address patient concerns about these state programs, even if they're not participating in the programs as a facilitator. They need to be prepared to answer questions or to refer patients to sources of current and reliable information. Often, these providers that are not participating as facilitators will be the first time a patient hears about what is offered within these programs in their state. And being prepared to answer those questions knowledgeably or refer to clearly updated, clearly available resources is going to be incredibly important for the long-term survival of these programs.
Anyone else?
Yeah, I'll jump in on a couple pieces, and and I think Victoria, to build off of sort of like the clawbacks, I do think that's like an important issue for those, if you're a provider and you're receiving insurance payments for your patient's care, of just making sure that like any sort of referrals follow the policies of that third party payer. And a lot of times there might be limitations on to what sort of care you can refer someone to. So like reviewing like the third party payer contract is really key. And then also I think one thing we think about is just around like referral liability overall. And it is in Colorado it is like a recognized claim around referral liability. If you refer someone to a provider and something is negligent, or that they're negligent, there could be potential issues or risks there. And so a lot of times like best practices is referring someone to multiple people if you're going to make direct referrals. And back to, and that sort of like does touch on Victoria's point around federal law. Like if you are making specific referrals to a specific person or multiple people that are violating federal law, like you're probably part of this like overall issue with federal illegality. And that is something to note and to flag. And with that said, though, it's like the case Victoria mentioned was about a physician who was held that he had the right to sort of like generally recommend cannabis to his patients. So if you're like generally recommending psilocybin care to your patients, that's different than if you're saying like go to Tasha's Healing Center. Like it's just like there's just a different line there. With that said, though, it's like, as mentioned before, it's like this whole program is still illegal federally, and we're sort of like all potentially complicit in its illegality. And so it's something that a lot of people have looked at and also feel comfortable operating under the protections of the state laws that we have.
And I'd like to just distinguish something that's different about Oregon and Colorado. There is no express referral mandate under Oregon's new law. Oregon law authorizes discussing psilocybin as a treatment option. It does not expressly protect healthcare providers for referrals to a facilitator. So all of the risks that Victoria and Joshua have mentioned, particularly related to, referral liability, are super important. I agree with Josh that, I would suggest referring to several facilitators rather than one specific one, or even directing a client, to the OHA's facilitator list on its website if you want to be even more generic. I think, people want to try to balance referring to reputable and credible individuals and also protecting themselves from liability, which is kind of a fine line to walk.
I imagine there may be a few folks here concerned about the clawback issue. I wonder if anyone could comment more on the kinds of documentation policy or practices that might be more or less likely to trigger clawbacks. If you have thoughts on that.
So where I see clawbacks the most often is, frankly, charting that does not do a good enough job of clearly distinguishing why certain treatment or certain testing or certain preparation was required independently medically from the recommendation to use a substance like ketamine or psilocybin. These things need to be independently medically supported. They need to be charted separately and they need to be coded appropriately, which I'm going to get into in a little bit more detail as we go throughout this webinar. But that lack of separation is a huge problem. The other thing that has resulted in a lot of clawbacks that I've seen is the beware the bundle problem, where people are referring to someone who's within their own practice or maybe referring to themselves, and they bundle the time spent on the administration of a substance with these separate preparation and integration services. That bundling results in a number of compliance issues as well as clawbacks. So it's good to know that it all starts with how you chart and how you train your staff to chart. I'll also throw in here, if you're thinking, well, I use AI charting and I've set my AI charting to separate these things out in such a way that I feel like I'm satisfied with. That's great, but AI charting can cause a whole other number of issues for you. You should still be checking the coding, and you should also be checking that business associate agreement that you have with your so-called HIPAA compliant AI, because calling something HIPAA compliant does not mean that every single way that you can use it is HIPAA compliant. And we need to make sure that you understand your business associate agreement and you understand your coding selections in the AI charting to make sure that you really are separating this stuff out and you're not accidentally bundling.
Yeah, and I would just add on that, just like it just makes a lot of sense to really review any third-party payer contracts from any insurance providers and making sure that, you know, what sort of limitations are either in that contract or in the policies that are also like incorporated into that contract around referrals. You know, like can you, refer, a patient that's being, patient from United to an unapproved illegal practice that you make money off of? Sort of like the potential issue, to be like pretty blunt, and so like making sure you're going through those third-party payer contracts and really understanding, hey, I can refer to, this group that I'm a part of or these other groups, that are not approved, sort of programs in the eyes of the federal government or the established medical community right now. And so a lot of times like that's due diligence just needs to happen on the front end, and there might be sort of like limitations on which patients you can refer to and which ones you can't based off of your other contractual duties to the insurance providers. And we haven't seen any sort of like in Colorado, we haven't seen any clawbacks around psilocybin at this point. It's just, it's too new of a program.
All right, thanks for that info. So maybe next question, perhaps a little narrower. Continuing with this question about healthcare providers who are wanting to discuss psilocybin services. So these could be either dually licensed or not, but they're working under their healthcare license and they're wanting to discuss psilocybin services. What kind of language should they use, or what kind of language should they avoid, like, prescribe or recommend? And I think this is you, Joshua, to start off.
Yeah, I mean, generally, our viewpoint is it never, it doesn't make sense to sort of like clear someone or give someone like the green light or the go ahead or the strong like recommendation to like use a substance that hasn't been approved, and so a lot of times, from a physician or medical provider standpoint, what you actually want to say is, hey, there's nothing that clearly limits you or would disqualify you or would prohibit you from engaging in this type of care. And this type of care generally might be helpful in these areas. However, it's not an FDA approved treatment. It's not, approved by our established medical community at this point. It's just like being very honest in your language, is really, really key, and not over promising too. It's not like, oh, psilocybin care will treat your depression, whatever it might be. It's just like these over promises also where you can get in a lot of trouble, as well. So, and from our standpoint, I'd love to hear, Victoria and Casey's thoughts on this, but a lot of times it's, there's nothing that disqualifies you versus like there's nothing that sort of like qualifies you into this care.
Yeah, I'm happy to jump in. I mean, I agree, Josh. We never advise our clients to green light someone if you're doing, and it's tough. I think a lot of providers in this space, they want to take a look at medications, health conditions, mental health history, and say like, you're a great candidate for psilocybin. But people need to be really careful with, that type of kind of go ahead. And I just would remind people again that in Oregon, the law only authorizes you to discuss psilocybin as a treatment option. Those are super limiting words, like I said before. And so avoiding, encouraging, endorsing, recommending psilocybin, don't guarantee results, rely on reputable scientific research to provide just information generally to clients that actually align with their like legitimate condition. And then, just discussing psilocybin within the boundaries of your existing ethical requirements of your professional license and letting the client come to their own conclusion ultimately. But, there should be disclaimers for sure about federal illegality and all of the things that Josh mentioned, that is best practice for sure.
I'll jump in here as well to just add on. I find myself nodding constantly whenever Josh or Casey is talking because everything they're saying is so, so correct. Something I'm reminded of when we have this conversation around what language a provider should be using to discuss something like psilocybin, think back to best practices for informed consent in the first place. Many of you may have heard in medical school or in another training program about a PARC conversation. PARC is an acronym for a conversational framework that goes procedure, alternatives, risks, and a check for understanding. And the reason a lot of people are taught that framework is because there is sometimes a hesitation to talk to people about the negatives or the risks of a particular treatment option. And we want to make sure that patients who are having these conversations with their doctors understand both all of the great things that psilocybin could do for them and all of the problems, including federal illegality, including the fact that we may not have enough information to ensure some sort of result coming from these treatments. When you're looking at your own consent forms and you're looking at the way that you talk to patients, I encourage you to think back to this really basic conversational framework that you may not have heard of since your first year of medical school. And think through, am I really giving the patient all of this information in a way that does not strongly encourage, clearly recommend, or prescribe an illegal substance? And if so, I think you're headed towards best practices.
Some folks are out there saying things like, I do psilocybin assisted therapy or I do psychedelic assisted therapy. What do you think about in terms of the risks involved with that kind of a framing on the healthcare side? If anybody wants to comment on that.
I mean, in Oregon, there's definitely some issues with like, psilocybin therapy. And I think like sort of like what is considered like psilocybin therapy versus like psilocybin care is still like undefined a little bit. Like, is psilocybin therapy, how broad is that or how narrow is that? I think is, sort of an open question to define. But, I think people, stating what they do, that they provide psilocybin care, or that they're a psilocybin facilitator in Colorado and they're licensed to do that, I think, falls within sort of like the boundaries of the program. If you're, obviously if you're saying like, hey, you're doing something then that's not permitted in your jurisdiction, there's, some issues there. So, in my mind, I think it's, very like case specific and context specific, like how that sort of like comes up.
Yeah, I would agree with that. I mean, I think now that Oregon's law, allows simultaneous practice for certain therapy providers, licensed clinical social workers, professional counselors and therapists, using therapy is appropriate. But even before this dual licensure law, we had a lot of clients who would want to say psilocybin therapy, and our recommendation was to not do that. Don't hold yourself out as providing therapy if you are not, in fact, providing therapy, and providing therapy simultaneously with psilocybin services currently and up until December 31st of this year is not authorized by Oregon law. So there's a lot of just some liability exposure there. And also it butts up with some OHA rules that we think OHA could use to issue a violation against facilitator.
I think we're in a really similar situation right now in New Mexico because we don't have licensing yet for our program. So if you are out here holding a professional license in New Mexico and stating that you provide these services, there's real potential liability not only in a legal sense, but in your ability to obtain a future license when the program becomes online. We don't know yet what the restrictions will be around applying for and receiving that license. So it's a really tender time to be choosing to push the boundaries here in the state of New Mexico. I've also seen a little bit of the problem with people who are primarily practicing in New Mexico, but they're licensed as facilitators, usually in Colorado, sometimes in Oregon, and will travel to put on specific retreats or work with specific healing centers in certain ways. There is where I think Josh is absolutely on point when it comes to New Mexico with it's so specific and case by case. Like, did you say I provide psychedelic assisted therapy, or did you say part of my practice is that I am a licensed psychedelic facilitator in the psilocybin program in Colorado who offers a specific service during these times in the state of Colorado? That's where it gets a little squishy, and I would advise caution.
All right, so moving on to the next one. So Casey, could you speak to the liability insurance landscape for facilitators, service centers, healing centers, etc., and the kinds of general things people might want to pay attention to in terms of considering policies?
Yeah, insurance, important topic. It's tricky in this space. I will say on the just service center front, there's commercial general liability policies out there. And Victoria and I were actually having a conversation earlier about some kind of add-on endorsements to service center policies that in certain contexts will like cover some malpractice for facilitators. I have not actually had a chance to review a policy like that. Maybe Victoria can speak to it. From what I've seen, the several malpractice policies that I have reviewed, I've yet to see one that provides coverage for simultaneous practice of healthcare or behavioral healthcare and facilitation. They tend to be separate policies. The professional liability policies, tend to exclude federally illegal conduct. The ones I've seen do not specifically cover simultaneous practice of psilocybin services. And then the malpractice liability policies I've seen for facilitators in Oregon have a lot of exclusions. They do not specifically cover simultaneous practice of another profession. They're very poorly written. And so there's a lot of potential insurance gaps. I have not been impressed by what I've seen. And I think that mostly derives from the fact that there's a real lack of understanding in the insurance world about the nuances of these programs. For instance, there's usually a lot of holdovers like in the exclusion section about, violating any law. And that there's usually not a carve out for federal law, right? We know that psilocybin is federally illegal. You need carve outs in the exclusions for any sort of psilocybin services that you're offering. There's also numerous, other issues I've seen. So it's really important because insurers are always going to try hard to deny coverage if they can. They want to find an out in a policy because they do not want to pay the claim. So providers need to be aware that, purchasing a policy with conditions to coverage that are difficult to meet, really bad improper terminology, broad exclusions, ultimately just means that if they're, trying to rely on that coverage in the future, the insurer may attempt to weasel out of the policy. Some clients want to go ahead for the right price point and like purchase it anyways, just in case, and that's understandable. But there's a little bit of risk that people need to be aware of, and the best line of defense in the absence of solid insurance coverage are contracts that limit liability. And the state mandated forms are not what do that. It's additional contracts that providers can enter into with clients, either as a facilitator, as a professional, or both, that really set some limitations on liability and boundaries with the client to help protect the provider in the future.
Y'all, this topic makes me so mad. My full Southern accent comes out. I had a long conversation with my favorite broker yesterday. Shockingly, there are some insurance industry people that I've managed to become friends with. And we were talking about this gap that it's, as Casey said, it seems like there's really not a good option for people who are operating in a dual licensed context to have one policy that covers both their facilitation and their medical practice. And that obviously opens up a lot of potential for denying claims under either policy if you have both based on federally illegal conduct. I have found two policies in talking with this broker where their company was able to find underwriters to write coverage for dual practicing facilitators who were working in a facility, in a larger facility, that had a policy that also covered them. They were able to write a match policy. That was it. As you can imagine, these things were incredibly expensive and suffer from the same problems that Casey so eloquently pointed out. The language is non-specific to psychedelics, the conditions of coverage are very difficult to meet, and we are in a situation where specific exclusions from coverage may apply due to federal illegality. I have seen a few creative people trying to build something different. The National Psychedelics Association is in the process of building and launching a captive that would focus on liability insurance for facilitators. That could be an add-on policy to existing professional liability policies. There are a few other captives that are being built. There are a few other specialty lines, mostly that worked in medical cannabis, that are considering entering into the space. But the insurance environment right now is not good. I would put forth two pieces of advice, one being insure the risks that you can. To the extent that you are able to insure your general liability, your business auto, to the extent that that is applicable, your cybersecurity risks, I would do it because those conditions of coverage are probably going to be much easier to meet and those rates are probably going to be much lower. On top of that, I'm going to echo Casey again and say your contracts are your first line of defense and your best line of defense in any emerging industry. Understand what they say. If you don't know what indemnity means, now's a really great time to get on Google and start familiarizing yourself with the concept and understand how it is that the contracts that you enter into allocate liability. Because ultimately, those contracts are going to be much friendlier to you if negotiated properly than any insurance policy that you're able to get right now.
Yeah, and I'll just jump in a little bit here. In Colorado, sort of like how it works is like if you hold like another license, you're a psychologist, you actually, are providing services as a clinical facilitator under the clinical facilitator license. And so, in some cases, people might want to make it really clear of like when their psychology work ends and when their clinical facilitator work starts, even though your scope of practice as a clinical facilitator includes the practice of psychology. And so like that might be like one way to sort of like help try and compartmentalize different risks and compartmentalize different like insurance policies. And so that's like just something to think about is like, hey, what does that structure look like? Where does the handoff look like? And then, I will say, it's like one good piece of news is that like the policies are only getting better. Like, it's like it's a new industry, it's a new space, it's not that big of an industry or a field right now. And so it's like we have some stuff which is better than nothing, and they're getting better. And so it's just something to like continues to note that like there's that the policies that will be around next year are going to be better than this year, and it's just going to continue to go that way. And that's what we saw in the cannabis space. That's what we see with every new industry. So part of it's just like having a little bit of patience there. And then the other thing too, around sort of like risk and liability, really does come down to like how you hold space and like are you doing the appropriate screening, and are you are you comfortable with the people you're working with? And then this is really a skill set that's been around in the psychedelic field for decades, where we've had people in the underground really who understand how to minimize risk by like who they work with and appropriate screening. It's like that's also a big piece of this puzzle around risk mitigation. But big picture, a lot of people in Oregon, to date, there's been 14,000 people have gone through it, and like very little issues You know, it's like we're not like seeing that this is like a high risk space. Like, yes, there are risks, but like, you know, it's not something that's like, oh my God, there's not insurance. Like I shouldn't do this. It's actually, oh, you know, there's not the insurance I would like. I should keep looking, and I should be more careful. You know, is sort of like my, you know, my 2 cents on the topic.
All right, lots of great wisdom here. And I think it's time to switch over to some of the questions from the Q&A. Natasha?
Yeah, thank you so much for leading the discussion, Jason, and to our 3 panelists. We do have some questions in the Q&A, and I want to invite you all to keep adding questions. One just quick kind of clarifying question. Sorry, I should have gotten this in while we were on the topic, but there's the question, what is a clawback? Provide a little clarity there.
Sure. So a clawback is when an insurance company has paid a claim and then, in its opinion, determines that that claim should not have been paid. So they go back to the provider and request those funds back.
Thank you, Victoria, for clarifying that. So we have a question focused on Colorado, so maybe I'll direct it to Josh. There appears to be no integration of the healing centers and current licensed behavioral health providers in Colorado. How would you envision us doing a better job of ensuring accessibility within our behavioral health community treatment to reach vulnerable and underserved populations?
Yeah, well, I mean, there are actually licensed behavioral health providers that are also facilitators in Colorado. So it's not that there isn't any, but I totally understand that maybe that we'd probably like more of that, you know. And I think, you know, part of that is like, you know, as insurance policies develop, as behavioral healthcare providers become more educated, as participants start to ask their behavioral healthcare providers about what they think about, you know, psychedelic care, you know, I think that will sort of like help us integrate it. One thing we have in Colorado that, you know, I don't think we mentioned yet is there is the ability to provide psilocybin care at licensed healthcare facilities. And that opens up like a different set of insurance and compliance issues for sure, you know, but we haven't quite seen that like really take off yet, and in part because like in order for a facilitator to provide care at a licensed healthcare facility, they have to have had worked at a healing center for I believe 4 months, and so it's like there isn't even like the facilitators that like actually qualify yet. I mean, you can have some other qualifications around hospice and other things, but you know, so you know, I think it's like still we're still starting to like integrate it, and it's like taking some time. Um, yeah, it's just taking some time there, and there are, you know, a number of licensed healthcare professionals that are facilitators in Colorado that own healing centers that are providing, so you know, that are providing care. Now, whether or not how integrated it is like another issue.
Yeah, and I'll just jump in really quickly and say one of the resources we've created recently with Healing Advocacy Fund is a list of CE, CME accredited courses that are focused on psilocybin therapy. And so to the extent that there's healthcare providers on the call that do want to deepen their education, that might be a good one to check out, because I do agree that part of what's needed is just increasing the base level of understanding and awareness of what psilocybin therapy is, how these state programs are structured. So I'll drop the link to the directory in the chat here for you all. But while I'm doing that, I will pull up the next question. So we do have a couple questions here about DEA licenses, so I'm going to read them both together. What risks are associated with federal licensure, such as holding a DEA license? Has there been communication with any federal agencies regarding the development of these programs? So that's one. And then we also have the question wondering about the risk of losing DEA licenses. Has there been news out of the DEA about how they intend to regard these state-based programs and participation in them by individuals with DEA licenses? So very similar questions there.
Yeah, I'll jump in, but I'd love to hear, you know, Casey and Victoria's views on this. You know, I'm not aware of any specific, you know, news or communication from the DEA about the participation of DEA prescribers in these state-based programs. You know, and if anyone has, I'd absolutely love to hear it. You know, one, you know, thing to note, there is the ability for the DEA to revoke prescribers' DEA registration if it's in the public interest. And this sort of, and that's what the statute said, and this statute has been used in the case of medical cannabis patients, in the case of medical cannabis physicians, and those participating like within the Death with Dignity programs. And in both cases that I'm aware of, there was like a big announcement, and this was sort of like a big concentrated effort by the DEA to use this provision to scare physicians from participating in either of the programs. And in both cases, the DEA actually lost. And and that's why you have Kona v. Waters, this like very infamous Ninth Circuit case that protects the free speech of physicians to recommend substances even if they aren't like legal federally. But there's limitations around that, which is what we talked about earlier. And so, where we are like this DEA piece is like there is like a risk, and it's in my mind like absent like it would require like a large policy change at the DEA or a large political change for that risk to become actualized. But there is, yeah. I'll just stop there. But I'd love to hear Casey and Victoria what your guys' thoughts are on this.
Happy to jump in. I also am not aware of any communications from the DEA around this. Like Josh pointed out, there's theoretical risk. If you hold a federal license of any kind, theoretically, a FAA pilot's license or something, like theoretically, you're engaging in federally illegal conduct every time you act as a facilitator and, conducting psilocybin services. Theoretically, the FAA could probably revoke your license for not complying with federal law. Same with DEA licenses. That said, it's just a matter of, in practice, what federal agencies are actually doing. And I am not aware of, any prescriber license, DEA license being pulled just because someone is participating as a facilitator in a state regulated psilocybin program. That doesn't mean that it won't happen one day. It just has not happened yet, as far as I'm aware. I think the risk is probably pretty low. I think the DEA and other federal agencies have higher priorities. If you're a professional, you're being professional in your conduct. I think that the risk is even lower. If you're being really cavalier, as a professional under your professional license, you're being cavalier with facilitation services. There's complaints against you at the board. All those things can kind of add up in favor of the DEA pulling your DEA license. If you're thoughtful, I think that the risk is probably pretty low.
I'll jump in just to add that, first of all, I'm also not aware of any specific DEA communication regarding these facilitators or these state programs. I'll also say that we've seen some really confusing conduct from the DEA when it comes to psychedelics, and that may lead you to draw some conclusions about where their priorities are when it comes to enforcing the theoretical risk that Casey so eloquently outlined. First, we've seen some movement on potential rescheduling of psilocybin. That is historic and absolutely amazing. It obviously has not been rescheduled yet, but we've seen some movement on a petition. Very cool. On the other hand, in June of 2025, we saw a recommendation from the DEA to schedule DOC, which is an important psychedelic research chemical, as Schedule 1, which is a designation that states that this is of no medical use and has a high potential for addiction. There are no reported deaths of DOC. We have very little evidence that people are even using this at any kind of volume outside of research studies. So this kind of back and forth conduct leads me to believe that we don't have a clear policy directive right now going on in the DEA when it comes to psychedelics, and that might develop as the length of this administration's term in office goes on. I'll also say that what Casey said about your cavalier conduct versus your professional conduct is really important. Where I've seen DEA licenses pulled from prescribers are in the off-label ketamine administration context, when people are prescribing huge amounts of at-home ketamine to people that they're not drug testing, they're not making sure they're actually using the substance, they're not evaluating their condition. Instead, they're kind of operating similar to, for lack of a better term, a drug dealer. People are coming in for very minimal appointments, if they're coming in at all. They're being prescribed these huge amounts. And eventually the DEA believes that that is not appropriate medical conduct. What I've seen in that circumstance is very similar to, I think, what a lot of people saw with the pill mills in Florida and in other places being shut down at kind of the end of the boom of Oxycontin. If you are someone who's clearly documenting why you're prescribing, if you're somebody who's following all the rules of your state program, and if you're someone who is a professional, a true healthcare provider over someone who's just trying to make money with your prescriber license, I cannot tell you that that takes your risk away, but I can tell you that, in my opinion, it lowers your risk.
Appreciate that. So I'm going to ask a few more questions from the chat, but I do want to, while I'm doing that, invite the three of you to share your name and information in the chat if you'd like to do that. Just recognizing that folks may have more detailed questions that they want to reach out about after the call, and let me know if you have any issues with doing that. So moving on to another question here. So Casey had mentioned that there are a few different business structure templates within Oregon with various documents required for dual licensure. For this person, it's both licensed facilitator and licensed professional counselor. Where can I find these document templates for both? Or should I include all required documents from both licensing bodies when working with a psilocybin client in the process of prep admin integration?
So let me clarify. The templates I was referring to are templates that our law firm has developed to, form businesses and provide, create contracts between a business and a client. So they are templates that our clients pay for, and then we tailor them and customize them, depending on the various business structure and specific circumstances for that client. So these are not forms. What I was referring to are not like forms that are available on some state agency's, website that have to be used. When we're thinking about documentation, if you are simultaneously practicing, you need to abide by the forms and documentation required for both licenses. You can't cherry pick, Now, if you are not simultaneously practicing, but you happen to be a healthcare provider, but you're only doing prep, admin, integration in your capacity as a facilitator, you have the OHA facilitation rules to comply with. You don't have to comply with the professional obligations of your professional license because you're not actually practicing as a healthcare professional in any of those sessions. So simultaneous practice, presents this opportunity, a requirement, an obligation to ensure that you're documenting everything in accordance with both licenses. So yes, if you're intending to simultaneously practice, you would need, documents from both licensing bodies that are required. But in addition to what's required by licensing boards or by the OHA, you should consider additional contracts with clients that help limit your liability beyond what any of those forms might do. So that was what I was referring to earlier, and hopefully that helps clarify.
Thank you for clarifying that, Casey. All right. So we have a question focused on Colorado. Can you clarify whether a person who is dually licensed as an LPC and an LCMF may conduct facilitation, preparation, or integration sessions virtually for clients located outside of Colorado? The LPC license is active only in Colorado. Therefore, therapy services cannot be provided across state lines, but the facilitation license appears to allow virtual preparation and integration. I'd like to confirm whether this is permissible.
I appreciate the detailed question. The big picture, it's there's just like a little bit more analysis that needs to be done here. But you are correct that let's put the LPC piece aside. Someone is allowed to do prep and integration virtually. So if you're a facilitator and you're working with a participant and they live in Florida and you do a prep session, you can do it on Zoom or some other, as Victoria might say, like some HIPAA compliant sort of like platform. And then you could also do an integration session there. Now there's an unknown question in this field overall around when does prep and when does integration step into psychotherapy? And where is this line? And so, or when does preparation step into like the practice of medicine? And so that is sort of like still being like, figured out, as we sort of speak. And, the more, the preparation is like, hey, here's what you need to expect. We're using this form that's already been approved by the state around screening. And, here's like what you need to expect in this session, is going to be different than if you start like unpacking, someone's trauma, or you start engaging in traditional psychotherapy principles. Likewise, on integration, there's a question like, when is integration sort of its like own standalone service that's like reflecting back on the psychedelic experience, and when does integration turn into psychotherapy, and when does integration turn into coaching or something different? And that is something, as a field, we actually need to like, there's a gap, and so, I mean, and, it'd be really beneficial for different groups to sort of like put together some guidelines of like where that line is. Now, as it relates to an LPC practicing therapy in another state, that is also sort of like, a lot of it depends on like the nuances of, the practice act of a licensed professional counselor, and when, is it temporary? Did the person live in Colorado and they're just, on vacation in Florida? Do they live in Florida? There's a lot of different questions around like when you can practice therapy in another state. And so it's my long-winded answer of saying it's like it's still sort of like this gray area of like what we're trying to figure out. And the rules in Colorado specifically say, you're allowed to do virtual prep and integration, but you're not allowed to like practice a profession unlawfully in another state. And that's what I got.
I was just pausing in case any of the other panelists wanted to hop in on that one. But if not, I will move on to another question.
I
Sorry.
could hop in just a little bit. I mean, just to kind of clarify, at least for Oregon purposes, I think this is true in Colorado as well. You can kind of couch a preparation session as like, it's just paperwork. Like we are filling out the forms that we're obligated to fill out, by DORA, by OHA. And if you're doing that, there's just certain situations where it is, like Josh was mentioning, it's helpful to figure out which hat you're wearing at any given time and then structure your business based on what is most beneficial for your practice, what's most beneficial for your client, and be consistent and uniform and methodical about that approach, every time. And there's situations where you could, bifurcate services in a way that might allow you to do an integration session just as a facilitator instead of as an LPC. In which case, you could do a virtual session with a client that traveled to Colorado to experience, psilocybin at a healing center or something. There's other situations where, depending on the conversation that occurs in an integration session, you might be wearing your therapy hat and you might need to ensure that you're having a therapeutic relationship with your client at that time and not just acting as a facilitator at that time. And so I think it really depends on the activities that are intended by that particular professional, the conversations that are intended, and then making sure that you're being super clear with your client about when you're wearing that hat and what the boundaries are. And okay, if we get into, this kind of conversation, like I'm going to have to stop this conversation as a facilitator and I'm going to have to pick that conversation up as, a therapist on a later date, or something like that. And I think that can be confusing potentially to clients if you're not super careful and super clear to your client about that. But I do think that there's a possibility for structuring things in a way that, where, your client could be kind of getting the advantage of virtual services in one session or therapeutic services in another, or just, facilitation services. But it can get tricky, I think.
Also, just jump in and add that before I spent the time and maybe the money, depending on whether or not you decide that you need a legal counsel to advise you on this, to make that decision, I would assess my own comfort level with stopping a conversation that crosses those boundaries that Casey brought up. If you feel really comfortable with your clients and saying, hey, this has crossed the line in what I can do virtually. Let's reschedule this and move forward. That's great. But that's not every person's personality, and that's not every person's relationship with their clients. So if that's something that you know that you cannot do or that you do not want to do as part of your practice, it may be better to hold off.
Super interesting question. And it does seem like one that's been introduced kind of along with this concept of dual licensure, in that my understanding is that Oregon facilitators have been doing remote preparation and integration sessions throughout basically the duration of the program there, including with out-of-state clients, given that many of the clients in the Oregon program are out of state. Correct me if I'm wrong, Casey. I don't know if that's the case for Oregon facilitators who are also licensed in a mental health field, given that up until recently, they did have to very clearly separate those two hats.
Yeah. And my understanding, is that in many jurisdictions, you cannot, host a, for instance, therapy session with a client who lives in another state. If you're licensed in Oregon and you're talking to someone who lives in New Jersey, that client needs to be located in Oregon in order to have that conversation. And there's like Josh mentioned, I think, there's some factors sometimes that can allow and authorize someone to have that conversation with a client. There's also some holdovers in some state from COVID that also allow that type of, conversation across state lines, but a lot of short of doing some sort of like 50 survey, 50 state survey, figuring out the laws in every jurisdiction. I think that can be difficult, but if there's a way to sort of bookend sessions, so we have a therapy session, we have a preparation session where you're just acting as a facilitator, we have an admin session where you're just acting as a facilitator, we have an integration session where maybe you don't want to act as a facilitator, you want to only act as a therapist. There could be a way to potentially structure that and potentially bill clients health insurance. But again, boundaries, documentation, ethical obligations, risk tolerance, organizational abilities, all of those things like play a factor. And each person needs to, think about the possibility of those things, like, just based on their own personalities, as Victoria pointed out, their own practices, and what they're capable of doing and what the boundaries of their ethical obligations are under state law.
Yeah, and it's an interesting one from a policy perspective. We only require one preparation and one integration session. And in Oregon, it's just even an optional integration session, right? And there are some people who hear that and sort of their jaws drop because that's probably not best practices for most people. But I do think part of the intent there is to allow a more minimal approach to what is formal preparation, what is formal integration, and to allow some of it to fall more into the realm of what is therapy. To sort of support this greater level of integration. So trade-offs there for sure.
Yeah. And I would just point out that there's probably a lot of people in the audience who are like, dual relationships. And that obviously is the first thing that comes to mind for a lot of people whenever we talk about like bifurcating services. And so, if someone is simultaneously practicing, in Oregon, the law specifically authorizes professional licensees to simultaneously practice. And so that presumably trumps any sort of like regulatory dual relationship ethical rules. So I think the legal risk is potentially lower in that situation. And arguably the statute trumps the regulations in that respect. That said, a lot of people do not like to, potentially risk their professional license and, have a violation brought against them by their licensing boards. I would just, remind people that dual relationship rules tend to drive at prohibiting relationships between clients and providers that like increase risk of exploitation, undue influence, like your professional judgment is impaired, you're violating a position of power. I don't necessarily think that merely providing psilocybin services that are authorized under state law gives rise to those ethical concerns every single time. So I think as long as the provider is being careful, not pushing their client heavily to purchase psilocybin services from them, engaging in some sort of like egregious behavior and follows the letter of the law and is professional, methodical, they have a strong argument to a licensing board that there are no dual relationship concerns, but it is obviously a matter of risk tolerance.
Appreciate that. Yeah, and I feel like a lot of this does also come down to risk assessment and tolerance at this early stage of the field. So a couple more questions here. Saying doctor in front of a name as a licensed facilitator, is this an issue or should this be separate?
I mean, I have maybe a thought on this. I think the question is, are you acting in your capacity? First of all, like, are you acting in your capacity as a doctor? Whenever you're providing facilitation services, if you're simultaneously practicing saying like Dr. Casey Homan, I'm not a doctor, full disclosure, but saying Dr. Casey Homan is fine, I think. I think if you're only acting in your capacity as a facilitator, like, doctor is a title. It's a title that you hold. I am Casey Homan Esquire, but am I making it clear to someone when I am or am not acting in my capacity as an attorney if I use the Esquire title? And so I think that's the question. If a client could potentially get confused and think, they sign this Dr. Casey Homan on this OHA form, but they're only acting as a facilitator. But I'm under the impression as a client that they're actually serving as my medical doctor in that moment because boundaries have not clearly been set. Then using that title in that context could be confusing for someone. And this is where, for instance, in our templates that we prepare for people, if we're representing someone who's a professional license holder and they're only going to operate as a facilitator and providing psilocybin services, the client services agreement says to them and has a disclaimer to their client, I am not acting in my capacity as your medical doctor, your therapist. I'm not providing medical advice, in connection with these psilocybin services. So you have something to point to so that you can say the client should not have been confused by what activities I was providing. So that's kind of my 2 cents. I would love to hear Victoria and Josh's thoughts on this, but that's sort of where my head goes.
I think it's really situationally specific based on the kinds of clients that you work with and where you're using these communications. This actually comes up a lot for me in my social media practice, where I have people who will advertise practices or advertise certain services and use their doctor title or their Esquire title or something like that in a capacity other than the one that they're acting in when they're providing those services. And they'll get reported for things like misrepresentation. And the question always is it clear what capacity that you're acting in? And if it is clear, how did you make it clear? If you don't have the answer to those 2 questions yet, I would think about it a little bit more and get an answer to those questions before I started using my doctor title when I was just acting as a facilitator. But you are able to. That's a title that you hold. I am Mrs. Victoria Satanovich, even though I don't constantly talk about being married. I'm Victoria Satanovich Esquire, even though I don't always use the Esquire. Those things are true about you, and that's great. But why are you using it? Is it clear when you're acting in that capacity and when you're not? And if so, how is it clear?
Are you wanting to jump in, Josh?
Oh, I think those are exactly, the right ways to look at it. And then, and just making sure that there's no sort of like implication of some sort of like doctor of facilitation, because that just doesn't exist. And then there's specific rules around marketing too that, you need to be careful of under these state frameworks.
So we are just about at time. I do want to say that we're going to be sharing out a follow-up email after the call with the recording, as well as a few resources from the group here, information about the speakers you've heard from. There's one last question. I'm going to ask it, and then we're going to close out the call. Is there anything that service centers should be doing to prepare for if/when psilocybin becomes descheduled? How would that affect state frameworks? I don't think we'll have time for a very in-depth, but if anybody has kind of top of mind thoughts on that, I'll let you close out with that.
I'll jump in with this really briefly. We've been working on a petition as a society with the Ames versus DEA cases to get psilocybin down to Schedule 2 since February of 2022. I think we are a long way away from true descheduling. And I think the focus right now should be on building our state programs and complying with them as clearly and openly as we possibly can, and collecting the data we need to show that these state programs work.
I think that is a really fabulous note to close out the session with. So thank you for that, Victoria. Thank you, Casey, Joshua, and Jason. And yeah, we just really appreciate your time and expertise. And we will be in touch after the call. Thanks everyone as well for joining us today.